Mayuri, hi, this is Professor Sania.
Good morning.
Good morning. Will you be able to join around 9:45? Will that be okay?
Yes, ma'am.
Yeah,
Yes, ma'am.
because we'll have a demonstration class right now. I'll tell this to Shweta and tell us in the scholar group as well that 9:45, it's like 10 is the timing because we'll have to practice right now.
Yes, ma'am. I'll immediately post it on the group.
Perfect. Thank you so much, Mayuri.
Thank you, ma'am. Thank you.
Is that Shweta, ma'am? Is that Shweta, ma'am?
Yes, ma'am.
Good morning.
Hello.
अच्छा आप ही हो ना बस ठीक है.
Dr. Duggal, you are there? I think we cannot see your video.
Can you see my video, please?
Yeah, now it's visible. Yeah.
Okay, thank you.
Okay. Thank you for joining.
Thank you, sir.
Dr. Ajit, we can start the program now.
Okay, sir.
Good morning, Dr. Mali. How are you?
Good morning, sir. How are you?
Good to see you. Thank you. Pleasure.
Same here, sir.
Thank you, sir. Greetings to all the honorable guests, participants, and the students. The International Conference on Interdisciplinary Aspects of Law and Technology is being organized at a time when the world is fighting the worst pandemic of the century. During this period of COVID-19, existing technology has taken a tectonic shift. The world has been experiencing a vital support from information and communication technology in saving the human race in this difficult time of COVID-19 crisis. The pandemic has dramatically accelerated the pace of acceptance of technological innovations. Online shopping has become the norms for the households. More and more people have shifted to the UPIs to effect money transactions. There is the spurt in the usage of internet and IT-enabled services, and educational institutions have shifted to the online tools. These are just a few examples which brought a structural change in our way of living during COVID-19. Technical innovations have serious implications on the human behavior, business, commerce, environment, and law. At the outset of the 21st century, information technology, digitization, and online marketing have given a new shape to the world process. Now, emerging technologies like artificial intelligence, big data analytics, and the Internet of Things have brought a complete transformation in the human life by raising the parameters of comfort and efficacy. But these technological innovations have also posed a challenge to the regulator to keep pace with the emerging technologies so that the people's rights are protected to maintain the rule of law. We have often experienced that the existing regulatory system is slow to adapt technological advancements. Naturally, it requires the lawmakers to address this disconnect between the technological innovations and the regulatory structure and process. In the above background, this conference deals with the themes related to the contemporary legal issues in this challenging time, with a special focus on law and technology. The conference provides an opportunity to various stakeholders to deliberate and discuss a strategy to re-examine the underlying contemporary legal issues related to the interdisciplinary aspect of law and technology. The conference contains 4 technical sessions to encompass the diversity of emerging techno-legal issues and 1 plenary session dedicated to the digitization of currency, which is a challenge at hand before the world. Being the convener of this conference, I welcome all the guests and participants, and I express my gratitude to them. Thank you. Now, I would call upon our Honorable Vice Chancellor to welcome the guests.
Thank you, Dr. Ajit. Welcome you all in the International Conference on Interdisciplinary Aspects of Law and Technology. Let me welcome all the participants, my faculty colleagues, and the very renowned scholars and also well-known figures in the area of cyber law, Dr. Pavan Duggal and Dr. Prashant Mali. They do not require any kind of introduction. They are well-known figures in the world, and they have done a lot of research, lot of professional thing they have done, and also they are able to drive the area with their kind of guidance, consultancy, and advice to several companies in the world. So thank you very much, Dr. Prashant Mali and Dr. Pavan Duggal for joining and finding time from busy schedule and gracing the occasion. We will be eagerly awaiting to listen your thoughts, and I'm sure we have more than 100 participants already on the Zoom, and also we have several hundred they're joining from Facebook and different social media links. This is a very important conference because the whole idea is that how to make the awareness and how to start thinking the way the market is growing, the way industry is growing, and also the way we are facing the legal challenges in the court of law. So already we are in the area of Industry 4.0, but the challenge is that a lot of universities and colleges are not still in the Education 4.0. And then we have the next challenges about the legal education 4.0, because we know we are still governed by the traditional model of teaching learning process, and also still we are teaching maybe several laws which are not actually required, and also we have to now work out and include in the curriculum several laws which are going to be the future because of the intervention of the AI, blockchain technology, and also we are going to see the quantum computing, and also there are a lot of kind of involvement of the cryptocurrency, the bitcoins and all, and also there's a lot of intervention of the artificial intelligence in several activities. There will be a lot of changes in the industry sector. It will be going to also affect the practice, also going to affect the decision making by the court of law. So in this scenario, I think it is very great that we are able to attract a lot of academicians from the entire countries of lawyers. They have written papers. There will be a intense debate in the coming 2 days on the various aspects of cyber law, cyber crime, cyber security, and also different intervention of these technologies in the legal education, in the legal profession. I'm sure all the participants will be able to do a lot of value additions, and also they'll be eagerly awaiting to listen the 2 great scholars today. They are available in this inaugural program. Let me welcome you all once again, all the people who are participating from outside, our dear students, faculty, colleagues, and all the my deans and directors from the university. And also let me thank Dr. Ajit Kaushal and Dr. Azim Pathan for taking the time and also able to organize the excellent conference. I'm sure it will be great value addition to all of us. So thank you very much, and I welcome you all once again in the inaugural function. Thank you very much.
Good morning, everyone. I, Arjun Arora, take it as my utmost honor and privilege to extend a warm and hearty welcome to our honorable guests, our honorable Vice Chancellor and Dean, sir, all the faculty. So sorry about that. And all the faculty members and people joining us online on our Facebook Live. To enlighten us today, we have amongst us Dr. Prashant Mali, sir, President and Founder, Cyber Law Consulting. He is the Chair of Cyber Law and Cybersecurity Committee of Indian National Bar Association. He is also the founder faculty for Diploma in System Audit from Institute of Chartered Accountants of India. I would now request, sir, to address the gathering. Sir, please.
Thank you. My resume seems not to be updated, but that's fine. It's available on the internet. So anyways, thank you, Tabreji, for organizing such a wonderful conference. I think this is the need of the hour. And to begin with, see, even though the topic of the conference is interdisciplinary, I want to put my thought today where something different is that today, if you look at progress, today we look at technological progress or technological innovations. Progress is happening, startups are booming where there is absence of law. They are trying to build upon what is called as, they are jumping the bandwagon where law is not catching up. Cryptocurrency, whether it is cryptocurrency, whether it is artificial intelligence or any new technology, whether it is robotics, absence of law is giving them something called as leapfrogging, and startups are booming on this. But absence of law doesn't mean that there is no loss for consumer. There are losses for consumers. If you look at all the new technology or new startup happenings like digital lending or edtech industry for that matter, or gaming or cryptocurrency, everywhere there is something called as lawlessness, or either there is no law or the policy of government of India is not clear. It's not only government of India, many governments have not made laws around it. So even though it is helping mankind in one way for leapfrogging using this technological innovations, but it is also putting hundreds and thousands of people, consumers at loss because the law enforcement are figuring which section to apply. And sometimes, many of the time, sections are there, but they don't want to apply because we know our police how they work. So if law itself is not there, they have a reason for telling us that there is no law at this point. So what I feel today at this juncture, a new thought I want to bring before all the honorable listeners and my co-panelist, learned co-panelist, is why not we also have one topic, one subject, which in our law syllabus, which talks about emerging law, the law which is actually not there. So what could be problems and solutions if the law has to be drafted? What could be the suggestional thing the law can actually emerge, and what could be the position of our country? Is there any law somewhere else? So a law which is not there. So it would be like proposing law. I know it could be 1 year, 2 years, 3 years, people will be keep proposing it, but it would also teach our students how to draft a law, or how a law gets made, or how a culture gets converted into a law. And what is the culture today? Technology is the culture, apps is the culture. So how take the real life problem, take the technology, take the culture and convert it into law. So they'll actually see law being happening, and on some sections, if they are picked up by parliament or the drafting committee, etc., they will have a lifetime galore for themselves. Okay, so this could be one thought which just came randomly while talking on your August conference. Second thing I want to bring in is now today we are looking at the new law which is constantly debated is privacy. I have just written a paper like bringing in a law is not bringing literacy of privacy in Indian culture. India by culture itself is open culture. In India, the problem is people are not aware about what is privacy and what is secrecy. Here, majority of us, or majority of the Indian population will equate privacy to secrecy. They are not aware itself about privacy. In fact, my dear friend Pavan ji will also agree that we are working towards cybercrime, cyber law awareness from years together. Yet today, after 21 years of this law being in the process, you get still people in law enforcement asking, is this section present? Or you will get a random call which section to be applied, and they'll apply some wrong section. You will still find police officers, including judges, passing orders on section 66A of the IT Act. So if we look at 21 years of this IT Act 2000 in our country, if we are not able to achieve the awareness which is required for prosecution of cases and giving justice to general people at large, then imagine privacy, which is completely an alien concept in our culture, in Indian culture, fighting for the law, bringing that law, and that the law is not going to the last section, to the rural India and to the rural India or the last user, the mobile phone user, who is now the last point, last mile, which is there in the rural villages. If we are not able to pass this law and the efficacy of this law to them, then it fails in its long-term targets. The learnings from IT Act 2000 has to be applied, should have been applied. If you see the other mistake being created is the same adjudicating officer provision which is being mooted in the privacy law, the data protection law. So adjudicating officer per se, leaving 4-5 states, have completely failed in last 21 years to give justice, to give damages and compensation to those affected under the section 43 subsections, etc. There are certain states, even bigger state like UP, Uttar Pradesh, they don't have adjudicator. So when you don't have a system which is devised to give justice, it gets failed after 21 years. Then how do you bring the same system and want to implement in the new law? The learning has to be there. So there are 2-3 learnings from the IT Act which has to be there. One was the awareness. Second was awareness in vernacular medium, which is the issue in our country. You go to French, they keep talking. You go to France, they talk in French. You go to various countries, Spanish-speaking countries, they have everything in Spanish. But you come to India, we are insistent on 1 or 2 languages. But essentially, if we want to drive the awareness, the fruits of technology, the fruits of digital India to the nook and corners of our country and see a complicit growth across technology and the law, then we need to reach to this each individual in vernacular languages, languages of the state, languages of the district. Then only we can have some kind of kranti in the cyber or privacy area as it comes. If we don't do it day one, then it remains confined to the books, to the intellectual, to the leftist, and to the people, scholars, who actually end up in studying it, or the need-based thing. And then we come up saying that there is no awareness. But awareness will happen when we talk their language, when we talk the people to whom the law has to be applied. When we are not talking their language, there will be lawlessness, there will be misinterpretation of law, there will be less awareness and hence less prosecution. And today's burning issue, if you read last 2-3 days newspapers also, poor conviction ratios. Why today we are having lots of cyber crimes are happening. I'm sure Pavan will also appreciate the amount of cyber crimes have increased, or in fact, every single crime has some connotation of electronic evidence today. So the difference between cybercrime and normal crime is also slowly vanishing. So what could be called as cybercrime is also, being challenged. And in this case, you don't have conviction ratio. You have 1 or 2 conviction in a whole state in cybercrime. It's such a poor thing. Yesterday, I was reading Times of India had come to me with statistics which was saying there is only 1 conviction among cybercrime on minors. Just imagine 1 conviction in 1 year for cybercrime on minors. This is a pathetic situation. This is the figure which Times of India gave me yesterday. When this is the case in different states, just imagine the bringing in law is one thing, debating, media debating, but what happens? When can the law be effective? When it is implemented. Today in India, the problem is implementation. And when there is 0 conviction, there are 3 limbs which are failing: the police, the prosecution, and the judiciary itself. When they are failing in conviction, certain things, the way we had lok adalats to finalize certain minor crimes. Today the need is, I suppose there should be cyber lok adalats, like where only cyber crimes gets prosecuted, where lawyers with cyber knowledge, technological knowledge, prosecutors with technological knowledge, and judges with technology knowledge sit together and dispose of matters to at least show to the world that we convict people, or we acquit people based on merits. So the merits and the case laws which we are trying to give to the future generation, they are not existing. We are not giving a light which will shine on the future generation. That's what's my today's contemplation. And I think that's the need of the hour. I think universities like GD Goenka and learned Professor Tabriz Ahmed, who is in forefront of cyber law education in India since so many years, with it, I think is one of his first PhD degrees in cyber law, etc. Should move government, should bring in certain courses, should tie up with these agencies, and do some experimental process where conviction is achieved. Today, internationally, when we are going, because of this poor conviction, it is not that it is only poor conviction in our country. Poor conviction is there in US, UK. I've read the figures, but India, it's certainly very poor when we look at the mass of the cyber crimes which are happening. Hence, I feel that when technology and law are getting intertangled, I know lawyers are always 5 years behind. Law is always 5 years behind the technology. Even though when this is the situation, when technology and law are getting combined, I feel law should be implemented using technology. Today, the problem is this: law is not getting implemented using technology. Just to give an example, we have e-commerce guidelines. We have new guidelines coming out for digital lending. Every time government brings in new guidelines, but one thing consistently gives a miss is ODR, online dispute resolution. See, online dispute resolution in matrimonial frauds, online dispute resolution, and e-commerce related issues. Anything which is services given online. If India has some policy about online dispute resolution, half the resolution of various disputes, various grievances which happen for small amounts, 2,000, 2,500 kind of amounts. Why to go to the courts? In fact, they don't get justice at all. 2,500 up till 20, 30,000 people don't get justice in our country. Money gone is gone. The irony is, you go in some mohalla or some gully, and if there is a theft of a television, then a television would be costing around 20,000 bucks. But then there will be a police van, there will be a signaled van of police, dogs would be coming in to find out who is the thief. But the next door person who loses say 1 lakh of rupees in cyber fraud, nobody's asking him. No police, no justice, nothing is happening. No police even visits to his house. He is sulking his own pain. So this can be changed with online dispute resolution, where technology and law can interface each other, and we could deliver justice. Today, delivering justice to common man, common digital India user is more important. Delivering justice to this cryptocurrency user, or whatever new technology we bring in, is more important than only launching technologies, or they will lose trust and faith on technology. Because once bitten, twice shy, people will go away from whatever good is built on technology because their grievances are not handled. With this, I think I rest my today's thought. I'm so happy to be here and so happy to see my dear friend Pavanji and Tabriji and others. Thank you very much.
Thank you so much, sir. We have amongst us today Dr. Pavan Duggal, sir. Sir is heading the Artificial Intelligence Law Hub and Blockchain Law Epicenter. He is the founder cum Honorary Chancellor of Cyber Law University. I now invite Dr. Pavan Duggal, sir, to enlighten us with his words. Sir, please.
Thank you, Dr. Tabriz, Dr. Mali, distinguished jurists, faculties, friends, ladies and gentlemen. It's a proud privilege. Clearly, when we look at the intersection of law and technology, that represents the present, and that's going to represent the future. Therefore, it's imperative that we need to have an orientation, a fresh pair of eyes. Why? Because ground realities are changing dramatically. The world that was existing pre-COVID has now given rise to a new world where we are finding new cyber realities facing us. And if we are not going to be ready, we are going to be lagging behind. I have a small presentation. Maybe if you can give me screen sharing rights, I could potentially be sharing my access. Oops, sorry. Clearly, when you are asked to address this inaugural session, you have various thoughts coming in your mind. But the first thought that comes clearly is that cyber attacks are everywhere. So these are not the new ground realities, and the various news reports tell us that we now need to be prepared for these new cyber attacks. The attacks are on companies, on individuals, on organizations, on governments, and even on international organizations. And these attacks will now continue to keep on growing as we pass with each passing day. Why is this so? Because we've already woken up in the data economy, where the data is the new oil of the new data economy. And this is the data that's going to be propelling our digital present and our digital future. Actually, we have ceased to be humans. We've become data entities. We are constantly generating data on a 24/7 basis. This is so because internet has made all of us into global authors, global transmitters, and global broadcasters of data. And the speed with which we are actually now transmitting data was unthinkable even 2 decades back. It's not just this data, it's my digital dust that I'm concerned with, the digital electronic footprints that I'm leaving behind for state and non-state actors to potentially be looking at. When I look at the statistics of the total quantum of messages, emails, direct messages, and tweets sent on a minute-by-minute basis, I'm zapped. Because so many people are now part of this global revolution. I call it the Great Vomiting Revolution, where people are vomiting information about their personal, professional, and social lives without even understanding the legal ramifications of the same. People are recklessly adopting new technologies. IoT, or the Internet of Things, is the latest in the case. Why? Because these IoT devices do not yet have internationally accepted norms on cybersecurity and are great predators of your personal privacy as also your data privacy. Clearly, the data economy has to be regulated. And that's where the law and technology intersection becomes of crucial necessity. Different countries are still a step behind. They are still in the e-commerce enabling mode legislation, where they by and large relied upon the United Nations UNCITRAL model law on electronic commerce. But then coming of COVID-19 has been a rude shock. Why? Because work from home has now become the new default option. But it's also brought in a new normal, which is that now employees are no longer willing to come back to work. They're willing to stay put at their own homes and stay put and do their work and their personal stuff at home. Now that suddenly brings the importance of cybersecurity, because in the last almost 1.5 years, we've seen a number of cybersecurity breaches targeting work from home devices and people working from home. Video conferencing, we've actually adopted to it like fish adopts to water. No wonder we think video conferencing is just as safe, just as private as we think or perceive it to be. Little do we realize that video conferencing generates humongous volumes of data. That data gets stored somewhere and has a direct impact on your privacy. Work from home is still an evolving concept. Therefore, the jurisprudence is still catching up. For Western nations who have been more prepared for this, they've adopted to it more naturally. But for countries like India, we find the teething problems continue to bother us, primarily because India has a unique vacuum, neither of having in place a dedicated law on cybersecurity, nor a law on privacy, nor a law on data protection. So during COVID-19 times, fear and panic were our two constant companions. I was also examining the impact of COVID-19 on cyberspace. And in my book, New Cyber World Order Post-COVID-19, I've argued that by the time nations are victorious against the current and subsequent wave of COVID-19 infections, the world will enter into a new cyber age, where there will be a new cyber world order, where states are going to become very, very powerful. And if you look at the legislations passed during COVID-19 in different countries, they all tell you one common story. More and more states are concentrating powers in their hands, currently for the purposes of fighting COVID-19, but ultimately for strengthening the cause of nation states at large. We are also going to see massive increase in cyber crimes during the new cyber world order. No wonder, with the coming of COVID-19, the golden age of cybercrime has already begun. And this golden age of cybercrime will continue to be with us for the next many decades. The kind of new forms, manifestations, and avatars of cybercrime during COVID-19 have been unprecedented. And the global impact, phenomenal. 2020, the world lost more than $6 trillion thanks to cybercrime. 2021, we should be losing more than $8 trillion by the end of this year, thanks to cybercrime. So in this intersection of law and technology, if there's one key message that arrives, that is that cybersecurity will now no longer be a lip service subject. We will have to start adopting cybersecurity as a way of life. Our thought process that we can do anything on our devices and our governments will protect our cybersecurity is a mistaken notion. We have to all contribute in this direction of protecting and preserving cybersecurity. The reason for this is that we are all part of a big chain on cybersecurity, and the chain is as strong as the weakest link. And we have to make sure that we do not become the weakest link in the chain. Why is it so? Because internationally, there is no international law on cybersecurity. There's also no international cyber law. So in this vacuum that exists internationally, countries have started coming up with their own distinctive national laws on cybersecurity. When I look at the list of nations who have come up with laws on cybersecurity, I find that the list is constantly growing. The leader in the pack, and the earliest one was indeed China, followed by a lot of other countries, including Vietnam, Thailand, Singapore, Australia, Egypt, and a variety of other states. Now, what's happening is that in this intersection of law and technology, governments are propagating the cause of and the concept of cyber sovereignty, where they say that their cyber sovereignty extends beyond the territorial boundaries of their respective countries. Artificial intelligence is no longer just fantasy, it's ground reality. But now the problem is artificial intelligence is being used for perpetuating cybercrime on the dark net, on the superficial net. Further, law enforcement agencies are also now using artificial intelligence for fighting cybercrimes. So the classical question is, what is artificial intelligence? Is it my friend? Is it my foe? Does it recognize my ethical values? Will it go ahead and respect my privacy? Those are fundamental burning questions that the world has still not been able to answer. And now with the draft artificial intelligence law of the European Union coming forward for discussion, I think the world is slowly getting ready for the evolution of artificial intelligence legal jurisprudence. When I look all around myself, I see not humans, I see data packets which are flowing all around us. No wonder big data is the new ecosystem of our times. And the big data legal issues have to be appropriately addressed, because this is the big data which will be the building block for the further digital economy of the country. We all, as humans, have very short memory. We love to rely upon things and forget about things. So cloud computing, we think, is an integral part of our lives. Little do we realize that one breach in a cloud could potentially get your entire system, your entire operations, and your entire data out of circulation for a short period of time. Blockchains are the now new mature technology that everybody is talking about. And blockchain is bringing to throw up new challenges. No wonder countries have started coming up with new legal frameworks for blockchains. So whether it's Malta, Estonia, or a variety of other countries, we find the fundamental question being sought to be answered. Should we regulate crypto assets, cryptocurrencies? Belarus says, yes, it regulates cryptocurrencies as crypto assets and gives them the shape of a legal tender, which is granted legal sanction and validity. India is still struggling to find out what it wants to do with the crypto assets and cryptocurrencies. On top of it, Internet of Things is now our present. We are relying upon the Echos and the Alexas of the world, thinking that they are our life companion, without realizing that they are listening to you all the time and invading your privacy at every given point of time. And now with the Internet of Behavior coming in, life is getting more complicated, because with the Internet of Behavior, they will be collecting all the data of your IoT devices, and they will be analyzing the same for the purposes of identifying your behavioral patterns and then targeting you with specific focused offerings, goods and services, depending on your behavioral patterns. A direct infringement of your right to privacy and your data privacy as a whole. But that's now the new reality. I can't run away from the new technologies and go to the Himalayas as a hermit. I have to be a part of this technology. And therefore, the scenario is it's important to be aware of the challenges that these new technologies bring across. Facial recognition, good, bad, or worse, is now a part of our modern day lives. It's being extensively used by governments, by corporates, and even by individuals. Hyderabad airport started using artificial intelligence and specifically facial recognition at their airport operations, only to find that there was massive outcry and consequently they stopped the operations. But now comes the difficult problem, which is that of quantum computing. The 50-qubit quantum computer has already arrived. And this quantum computer is now going to be used for breaking passwords left, right, and center. In a couple of years, our passwords will be history. Therefore, we will have to now look at new approaches on how to secure our own data, and therefore the legalities on the intersection of quantum computing and law would have to be appropriately addressed. And the latest avatar to catch the imagination of the entire world is metaverse. The metaverse, which has been so much in the news in 2021, because so many companies have committed billions of dollars to spending in the metaverse. The city of Seoul has become the first city in the world to have a presence on the metaverse. So much so that there was recently the first marriage that took place on the metaverse between two digital avatars of two people who simultaneously got married in the real world as well in the US. So metaverse brings across its own legal and policy issues, which will have to be appropriately also addressed as we go forward. And if you think your superficial net is your home, think again. Very quickly, as part of the new cyber world order, there's an expected trend that more and more people are likely to move away from the superficial net onto the dark net. Therefore, darknet now is an essential element of our digital existence. Why? Because you are anonymous, I'm anonymous, and cybercrime is the economic model on the darknet. But how do you regulate the darknet? Specifically, how do you ensure that the darknet does not get misused for perpetuation of cybercrime elements? Clearly, in this entire ecosystem, therefore, on the intersection of law and technology, I find that data protection becomes of massive importance. A lot of countries have come up with dedicated laws which are aiming to have a golden balance between protection of data, protection of privacy and digital rights of users on the one hand, and the protection of sovereign interests of sovereign governments on the other, vis-a-vis data and access to the same. And on top of it, the cyber attacks by state and non-state actors are completely changing the landscape. Today, all nation states are engaging in covert and overt activities. And these cyber attacks are now increasingly going to be a big challenge for all stakeholders as we go forward. The alarm bells are already ringing. They say we would be losing more than $10.5 trillion by 2025. I don't agree. I think this 10.5 trillion should come much well before 2025. Because the nature and the manner in which how cyber criminals and cybersecurity breaches are proceeding forward in their direction. And their most favorite tool at their disposal today is ransomware, a remarkable tool which allows them to extract ransom on targeted computer systems and data, and not even giving the promise of returning back access. Today, increasingly, most of these ransomware attacks are in the form of malware, spyware attacks. They completely wipe out the data while they promise to be a malware. And even if you pay them the money, they will never return back your access to the data to you. So clearly, when every 11 seconds, a company is getting a victim of a ransomware attack, ladies and gentlemen, the time has come for us to wake up, that we potentially could also become a victim of a ransomware attack. It's in this context that the entire concept of data protection assumes massive significance, whether it's the GDPR in the European Union, and whether it's now the data protection law in India that's coming up. These are different manifestations of how sovereign governments are trying to regulate the entire facets of data protection. On top of it, in this ecosystem of intersection of law and technology, if you're expecting privacy, then you need to have a relook, because most of your privacy apparently has already evaporated. And therefore, whatever little remains requires a lot of effort by you to protect your own respective privacy. The GDPR gives you the right to be forgotten. And I think this is going to be a fundamental tool in the hands of individuals as more and more governments start giving access to the right to be forgotten, including the right to be forgotten as part of the Indian PDP bill. The Joint Parliamentary Committee's report on the Personal Data Protection Bill has effectively endorsed the said bill, but has argued for expanding the scope and applicability of the same to not just personal data, but also to sensitive personal data per se. On top of it, India is confused. Should it regulate crypto? Should it not? Should it only go and regulate the Indian digital currency or the Indian digital rupee that the RBI is coming up? Therefore, the government has announced that it will be coming up with a cryptocurrency or a crypto asset bill. We don't exactly know what it will be, but whatever it is, it will definitely have impact on the crypto ecosystem. Therefore, I think somewhere down the line, we need to take a more holistic approach as organizations, as individuals, and as data stakeholders. And if you're in India, ladies and gentlemen, you have to quickly start seeing the writing on the wall, which is that if you're doing any activity in the digital ecosystem, you have no choices but to comply with Indian cyber law, being the Information Technology Act 2000, which over the last 21 years has had a massive traveling of a journey. From just beginning as a sector-specific legislation, it's now become the mother legislation for everything digital in the Indian context. So in this entire state, therefore, intermediaries become very, very important. Now, India has been slightly having a shift in terms of its legal stand on intermediaries, and now, by virtue of the IT rules, is wanting intermediaries to be more responsible, more accountable for whatever happens on their network. Under the IT Act, Section 71(9) of the IT Act mandates intermediaries to exercise due diligence while they discharge their obligations under the law. But we saw a honeymoon period of intermediaries from 2009 till 2021 February, when they remained just as mute spectators, because they were actually forced to become mute spectators thanks to the judgment of the Supreme Court in the case of Shreya Singhal versus Union of India. It's only February 2021 that the IT rules have now changed the color. However, the Shreya Singhal judgment still remains, which actually asks these intermediaries not to take any action till such time they get a court order or an order from a governmental agency. But the reason why the IT rules 2021 have become more significant is that they have come up with far more added compliances for various intermediaries. And if they don't do that, then there is exposure to legal liability for intermediaries. In the landmark judgment of X versus Union of India by the Delhi High Court upheld various provisions of the IT Rules 2021. I had the opportunity to assist the Delhi High Court in my capacity as an amicus curiae in the matter. But I think the changing catalyst in India will be Rule 7 of the IT Rules 2021. Because this rule categorically says that if an intermediary, you do not comply with the provisions of the IT rules, you not only lose your statutory exemption from legal liability as an intermediary, but more significantly, you become liable for being punished for various offenses under the Indian Penal Code and the Indian IT Act. So if you are a Twitter and you don't comply with the Indian IT rules, you quickly find that after the expiry of the statutory period for compliance, you get straddled with 4 different FIRs and 4 different criminal prosecutions in different states, where in each prosecution, you'll have to go and protect your own self. Therefore, I think the focus will have to increasingly be on compliances, on cybersecurity, and on digital transformation and the digital economy. Problem is, India has to quickly do its homework. This legislative vacuum in India is hurting us. No law on privacy, no law on data protection, no law on cybersecurity. So try getting any effective remedy to any problem that you have, and the chances are that you will potentially fail. Further, there's an entire issue of, India has this remarkable capacity of doing cut and paste. But I've seen that the cut and paste model often does not work. What India currently requires is not reinventing the wheel, but customizing the learnings of other nations so that they can potentially be more focused in this regard. We need to quickly learn from the learnings of other countries as we go forward in regulating the intersection of law and technology. And it's in this context that I believe that there is a need for massive capacity building. And this capacity building is going to be crucial. Therefore, events like these assume far more significance. We have come up with an online portal known as cyberlawuniversity.com, where we offer various courses online on the intersection of law and technology, including international certification courses on cyber law, cybercrime law, artificial intelligence law, blockchain law. We've tied up with various academic institutions, including the G.D. Goenka University, the National Law Universities in Ranchi and Orissa, and we're coming up with various offerings. So if your courses get subscribed by more than 27,000 students over 3 years from 172 countries, speaking 52 national languages, the figures tell us that there is a need for massive capacity building. And as participants of this event, we need to understand that we will have to constantly update our skill sets. At our law firm, Pavan Duggal Associates, we find each day is a new day. Why? Because when we assist clients in the various elements on the intersection of law and technology, we keep on learning every day. Ultimately, as I conclude, I can just tell you that intersection of law and technology is the present and is the new future. And a lot of work has to happen. And therefore, as students of law who are interested in this space, you can be now assured of one quick element, which is that there'll be plenty of excitement waiting for you. I would like to conclude finally by the words of Robert Frost, who said that the woods are lovely, dark and deep, but I have promises to keep and miles to go before I sleep. And miles to go before I sleep. I think these miles will have to be very quickly traversed. It'll require time, patience, but organization of events and conferences like the present International Conference will go a long way, not just in creating more capacity building, but also in making the relevant stakeholders more aware of the constantly newly evolving challenges and legal nuances on the intersection of law and technologies. I would like to thank G.D. Goenka University for organizing this wonderful international conference. My congratulations to the organizations, to the winners, to the participants of this conference, and of course, to the various session participants. This is going to be an exciting time. Wishing you all the best, and thank you for giving me this opportunity. Thanks, and over to you, Mr. Chairperson.
Thank you so much, sir. I would now like to call upon Professor Dr. Azim Khan Patan, sir, Head of Department School of Law, to initiate the release of conference proceedings and propose a word of thanks. Sir, please.
Thank you, Arjun. And very good morning, one and all, once again, on this August gathering on the occasion of this International Conference on Interdisciplinary Aspects of Law and Technology. Long back, Lee Lowinger, one of the famous authors, has already stated, and I quote him, that necessity is the mother of invention. And he further said, and I quote, that in present century, technological inventions, technological innovation, and technological growth has become the mother of necessity. Indeed, there's all kinds of inventions, innovation, technological growth, data, different important aspects and different important emerging, technological growth, indeed, directly impacting the life of society. And obviously, it has become the necessity. Earlier, Lee Lowinger has stated that in earlier century, necessity was the mother of invention, but now it is totally different. The technological invention and innovation has become the necessity of or we can say the mother of necessity. And obviously, this particular conference and different inputs which have come from the side of our honorable guest will give the different important directions for this particular conference. On this August gathering, with the consent of our honorable guest, Honorable Advocate Pavan Duggal sir, Honorable Advocate Prashant Mali, our Honorable Vice Chancellor sir, with their consent, I would like to release the proceeding of this international conference. So, Mr. Arjun, indeed, this is the souvenir of this entire international conference, an entire outcome of this international conference on law and technology. And I consider this is my proud privilege to propose the vote of thanks today in this August gathering. I am so much grateful, and it is my privilege to extend my heartfelt gratitude to our honorable guest, chief guest of this conference, Honorable Advocate Pavan Duggal, for his very important, insightful, guidance and direction, where he has stated that how exactly data has become the oil for this entire, the legal system, how exactly digital footprint, how exactly data economy that has to be indeed regulated, big data, cloud computing, blockchain, facial recognition, darknet, ransomware, cryptocurrency, these all important, the areas, how exactly we have to, tackle in coming time, and how exactly this legal system has to also work further, and what exactly will be the way forward. So I'm so much thankful to you, sir, on behalf of entire G.D. Goenka University and School of Law, and on behalf of our Honorable Vice Chancellor, sir, and topmost management of the G.D. Goenka University. Indeed, I am also thankful to our honorable guest of honor, Advocate Prashant Mali, sir, for his insightful, the guidance for this international conference, where he has stated in the context of how exactly, technology has become the culture, how exactly technological innovation, how exactly, indeed this technology and technological growth, and then more specifically the cyberspace, with the help of, the awareness among the people, with the help of vernacular language, with the help of, their understandable language, it can reach to the, common man and to the last person of the society. In that context, he has also suggested certain important online dispute resolution, how it should become, the primary focus for, reducing the pendency of the cases as well. and how exactly now, the cyberspace technology can also help, further for this legal system and many more, important issues which are coming to, grow in this society. So I'm so much thankful to you, sir, for your enlightening, the words of wisdom in this international conference on law and technology. And I'm also so much thankful to you on behalf of entire, GD Goenka University School of Law, on behalf of our Honorable Vice Chancellor, sir, and School of Law. Thank you so much, sir, for coming here and, giving your time, valuable time for this international conference. I'm also so much thankful to our Honorable Vice Chancellor, sir, Professor Tabriz Ahmed, for always guiding and motivating, in this unexplored area, and especially unexplored area, to explore once again and, go ahead in this particular area and to, bring out certain important outcome based, or certain important outcome which can contribute to the society. So thank you so much, sir, on behalf of entire School of Law for your benign presence for this international conference. I'm also thankful to organizer, Dr. Ajit Kaushal, Dr. Aditi, then besides that, Mr. Shreyas, an entire, this organizing committee, including the student members, Mr. Arjun and others, for, organizing and, taking ahead, many important, the activities for, organizing this international conference. I'm also thankful on behalf of GD Goenka University and on behalf of School of Law to all participants, all chairs, co-chairs of the conference. At the same time, all, head of the department, all deans of the different universities, different schools, and GD Goenka University's dean and director and different, the members. So for their benign presence for this August gathering on this occasion of international conference. I'm also thankful to all participants once again, and thank you to all guests for giving, their valuable time for this conference. Thank you so much.
Thank you so much, sir. With this, we now come to the end of the inaugural ceremony. Thank you all for joining. We will now be moving forward to the technical sessions. Thank you.
Thank you.
Thank you.
Thank you, sir.